John Campbell. I have a unique perspective. I'm an attorney, and I have filed several lawsuits against payday lenders. And like the payday loan industry that appeared here today, this bill would probably put me out of business in those lawsuits too. But I'm in support of the bill. Here's why. I want to address some of these myths that become facts, and maybe we need to turn it around. First of all, 90% repayment rate, you got to take a look at what that means. Under the existing law, as Representative pointed out, you take out a loan, you come back in the store 14 days later, and pay off means you pay it off and take it back out. Now, what that means is, if you have a loan for $400 and you owe $400 or $500 now with interest on that loan, as long as you make $500, you can walk in with $500, lay it on the counter, pay it off, and then leave with another $400 loan. So what we have here is a cycle of debt. And this is incredibly common. In fact, what I experience from most people who walk in my office. Let me address one other thing. This idea that the APR is not fair because it's a 2-week loan. When you have a loan repeatedly, day after day, for 6 months, you should measure the interest on a yearly basis, and the interest is real. I have clients that took out one loan, had that loan and its predecessors that were paid off and taken back out for 18 months. I don't think we should measure it by 2 weeks. It was a year and a half. That's what we're at right now. We're seeing loans that are walking in the door and existing for extended periods of time, taking tremendous amounts of money out of people's pockets. Let me just address this 36% annual rate that you couldn't make any money at. I was looking at QC's board back there, and it looks to me like on a $500 loan, you could collect about $180 in interest in a year. And then I believe the bill would have allowed for $25 at every loan origination, and you could get up to 4 a year because they're 90 days each. I mean, that sounds to me like you can make $280 on a $500 loan. That sounds like good money, because if you came to my house and wanted to borrow money from me and I'm not a payday lender, I can charge you 9% on that money. If I'm a payday lender, I'd be able to charge you 36% under this bill. So the idea that you can't make money, I think, as the credit union gentleman just expressed, you can make money. What you can't do is make too much money, money that puts people in the hole. The only businesses that support payday lenders are payday lenders. Okay? The businesses don't support payday lenders because what they know is when you're paying 469% to a payday lender, you're not paying them. You're not buying things in the economy. Okay? You're not paying your house. You're not paying your utilities. So this idea that somehow this is a harmless industry is a myth. It's not a harmless industry, it's a harmful industry. Now, I understand there are a lot of people that work for payday lenders, but I think if we went out and their employer wasn't here and we talked to them about it, they'd be able to tell you some stories of people who are in dire straits, hurting very badly, who, yes, they ended up at a payday lender, and yes, they took out that loan because they needed to pay the bills, but they didn't know where they were headed. They didn't understand that what they were buying was a year of trouble for what was at once a month of trouble. Let me treat it this way. Maybe morals from a lawyer are out of place, but I grew up with a family that said, do what's right. If my neighbor came to me and said, John, I'm dead broke, I need some money to keep the lights on, can you help me? And I looked at him and said, I'll loan you $100 to keep the lights on. I'm going to have to charge you 500%, but I'll give you the money. I wouldn't be much of a neighbor. We ask corporations to be treated as citizens. I think we ought to ask payday lenders to act like responsible citizens, charge reasonable rates, and continue to do that and make money any way they can like any other American business, but not at the expense of people's safety or our financial security. The subprime lending industry that we saw with mortgages was loose credit. It was credit given because people needed it, they wanted it, and they got it. Businesses gave it because they thought they'd have an immediate return. The problem is we saw where that went. This is the last haven of irresponsible lending, and I think we have to look at all the loan products that carry these kind of rates, including title loans that can take people's cars, payday loans, consumer installment loans, and ask if this is really something that is good for Missouri or good for our citizens or good for most businesses. I'll end with this because I want to give you a real life example. I brought a payday loan contract with me. The amount financed was $400. The interest was 469%, and the amount due after 1 month in full was $549. This was given to a woman who made $1,000 a month. She was disabled. Okay, she doesn't have any other income. That's what disability is. So she had $550 she owed at the end of the month. Anybody who makes $1,000 a month or ever has knows you don't have any fund money. That pays to keep the lights on, keep food in your mouth, medicine if you need it if you're disabled. It pays to make sure you have a place to sleep at night. When you pay 55% of your monthly income to a payday lender, you're not going to pay the other bills. So you got two choices. Pay this in full and end up homeless, or do what I described before. Either renew this loan, or pay it off and take it right back out and keep on going. Or, as you described, go across the street and get another loan because you're so frightened of what will happen when the payday lender calls again. From my experience, and that's just what it is, this idea that we can continue to tolerate this in the state of Missouri is unacceptable. The world will not end by making businesses charge 36% interest. The world won't end by telling consumers you have an option to borrow, but it won't bankrupt you. In fact, we'll be a little healthier and a little better off. For all of you who are looking for jobs, those credit unions can hire you. All right, we'll have a market filled with new products that are more safe for all of you. And I want to thank each of you that's supporting this bill. I hope you give me nothing to file lawsuits about. I hope that's where we end up, because it would be a wonderful thing for the state of Missouri. So thank you.
You talked about QC Holdings being able to make good money, and I got to look at their fourth quarter report and their record year income with $220.6 million in revenues. And then, go ahead.
Oh, I was just going to comment. I think in 2008, QC, who was here presenting about payday loans, had $47 million in revenue in Missouri. So yeah, it's a good business. It won't be quite as good at 36%, but I don't think it's a business that people will run from. I'll consider opening a store for 36%.
The other question I have for you, though, if you have lawsuits, I mean, I don't think, it doesn't seem to me they're doing anything illegal, because our laws are so weak they can do all this.
Well,
so how does this work?
Let me give you an example. The law says you have to consider the ability to repay. Right now, if you go into a payday loan store, I think you kind of heard, you can have a negative balance in your checking account. You can be absolutely disabled, provide no proof you have any other income, and borrow 80% of your income. Suggesting that's considering the ability to repay, frankly, it's considering the inability to repay. What payday lenders want is an annuity in people's lives. They want to know that when you come back in, you'll pay the interest, or the interest and a little, or take it back out, because where the good money is to keep you in for a year. The good money isn't come in 2 weeks, pay $100 and $10 in interest and leave. So that's one of the things. The other thing is that this renewal idea, the legislature said only 6 renewals and pay it down over time. That was a good idea, because that meant you could only be in it 12 weeks, and then you should be done, and you could only pay 75% over that period of time. That would have kept the interest rates down too, because you couldn't charge too much interest, or you would have collected too much. So there was an easy way around that. What you do is you pay it off in full. So like this loan is stamped paid. Well, this client had another loan the same day. In fact, a lot of times the new loan papers are printed before these are signed, because they say, oh, they're coming back in, print the new papers, and then have them take out the new loan. So now what you got is, you don't need 6 renewals, you don't have to lower the interest, you don't have to pay it down, you just flip it over time. So that's a couple of the things that I think violate the spirit of the law, and certainly what the legislature intended. I don't think the legislature went through the trouble to write the law that exists to make sure people could stay in loans for 2 years.
Thank you.
Sure, thank you.
So what is the legal basis of the claims that you're bringing against the industry? And secondly, what's been the result of some of your lawsuits?
Well, here's where we are. First, on the backside of this, there's about a 1,200-word document that's called an arbitration clause. And so what they did in here is they said that you can never file a lawsuit with a group of people. Well, you can imagine if you try to file a lawsuit for one person for $500, that doesn't make any financial sense. I mean, a lawyer can't afford to do it. The client can't afford to pay you. So QC had about 400,000 customers in 5 years, and they'd never had a lawsuit. Boy Scouts get sued, churches get sued, payday lenders don't. So the good news is Missouri courts have declared this arbitration clause unconscionable and thrown it out. So now we're able to proceed with a group of people. We're doing that now. And the basis of our claim is that this is essentially a violation of the Consumer Fraud Acts in Missouri, that this is an unfair or deceptive practice. Frankly, I think the interest rate alone could be considered by a court or an arbitrator unfair or deceptive, as some states have just said, it's way too high, we can't stomach it. And so that's where we're at right now, is working through those. Thank you.